to be the controlling paradigm. You don't pre-decide it. You let some other discipline like politics or law decide what your objective is, right? Let's say your objective is to deter crimes. Okay, the deterrence of crimes generally, regardless of whether it produces efficiency or whether it produces utility, let's say that's your objective. You can still have a empirical study of that legal rule which is supposedly deterring crimes. Say you have a death penalty, you have the imposition of a death penalty for some particular crime. You can easily just engage in positive law and economics to see, is this death penalty as a cost on individuals who have committed certain crimes creating an incentive to not commit them? Is it really deterring people? And that's something that can be studied empirically without applying any normative standard from economics. All right, I'm just trying to differentiate the positive law and economics angle, where you're just studying how things are things resulting in some kind of betterment or some kind of achievement of a pre-decided goal. You're not you're not imposing your own normative views in it. And separate from this kind of positive analysis is normative law and economics, where you have economics provide this kind of a normative standard, efficiency. And this normative standard is held up as the standard against which you assess your legal rules. What you try and do is you figure out whether a legal rule as it currently stands produces higher efficiency, or does it reduce efficiency as compared to some other system. So very simplistically, these questions, when we talk about questions of allowing markets to remain unregulated versus requiring markets to be subjected to particular legal rules, the question that economists pose that they have in mind is that markets produce greater efficiency because individuals are able to transact, they're able to determine what is going to benefit them instead of a legal rule determining what should benefit them. And that broad efficiency paradigm is applied further even when comparing different kinds of legal rules, right? Some economists, some scholars of law and economics, they try and propose this particular standard as a wealth maximization standard, in which case they are trying to apply some kind of monetary measurement of efficiency. They don't necessarily have a market for all the things that are actually being dealt with by a legal system or a legal rule. There's no real market for certain things. So sometimes you have to hypothetically imagine that there is a market and then determine whether or not wealth is being maximized. So you try and, what they suggest is that you try and produce those outcomes in society that a market would produce if it was there. And if there had been a transaction between two people, then what would have happened? How they try and impose this is they try and impose duties on the person who has the least cost in avoiding some kind of a bad sorry an undesirable social situation. Whoever has the least cost in avoiding that situation has the duty imposed on them. But we can of course differentiate these monetary ideas of welfare from monetary measurements of efficiency from ideas of welfare generally, where we face methodological problems in research, which is that you'll be dealing with things that cannot really be assessed, measured in the way that economics aspires to in a scientific way. If you pick up ideas of welfare which are not linked to monetary measurements, right? Um, Another standard that really gets applied, one specific standard that gets applied in law and economics is this kind of an efficiency, this concept of efficiency, which is called Pareto and Calder-Hicks efficiency. These are two kinds of efficiency that are talked about, that are held up as a normative standard that you apply to figure out whether a legal rule is doing the right thing, right? To explain these two concepts, this graph should probably be helpful. All right. On the X and Y axis, we have the levels of utility of two participants in some kind of a, let's say, a policy situation, that there is some kind of a problem in which two participants their utility is in some way capable of being rivalrous. All right. So I'll give you an example immediately after this. So, but just follow the graph for now. Let's say you're at position K, all right, On point K in the graph, the levels of utility of the two participants, the participant on the x-axis and the participant on the y-axis. Let's say that's a given. K is given. If the utility of participant X at a particular time is this, if it's 0 on the x-axis here, it will be 0 on the y-axis. That's the starting point, let's say. Starting at K, at this particular point, this binary of the levels of utility of these two people, the question becomes, when you want to produce some outcome by applying some policy measure, which direction do you want to be going in? And the possible alternatives that you pursue, the possible alternative policy measures that you pursue, can be broadly divided into these two areas: the green area and the red area. If from point K you move away from the origin into the green area only, and you limit yourself in the green area, what do you think precisely is happening there? You move from K away from the origin and you stay within the green area. If you do so, what you are doing, all movements from K towards BC, is resulting in some benefit either to the x-axis participant or to the y-axis participant or to both. It is basically resulting in benefit without any cost. Nobody is made worse off, and somebody or other is definitely made better off. Right. Now you'll immediately realize that this is the kind of language that economics often pursues when, for example, it promotes capitalism as a enlarging the pie, a scheme by which you can enlarge the pie. You're not concerned about what are the slices, how big is the slice that somebody is getting as compared to somebody else. Instead, you're just concerned that everybody gets a bigger slice. So you don't really care about who gets what size, as long as everybody gets a bigger size than they would otherwise. Right? So that's what's happening in a Pareto efficiency, a Pareto improvement. And there is a frontier which just represents what are the possible relations that exist. It's sort of like a production possibility frontier, right? You can only have certain relations, certain relationships between the utility levels of two participants in a problem, beyond which, because of technological limitations, because of the limitations of that social reality or the natural physical reality in which that policy problem exists, you are unable to go beyond that. So that's your Pareto frontier. What a standard of Pareto efficiency does not do is that it does not explain where on line BC you should stop. Any point between B and C is equally Pareto efficient according to standard of Pareto efficiency. So that is a standard that largely people suggested is it's about the minimum betterment that can be done on a minimum criteria of economic betterment, but it does not explain a large number of other questions where you are actually faced with some problem of having to decide where between B and C you want to place your utility level. The other concept that you need to have in mind is, if from K you move away from the origin but towards the red areas, if you move into the red areas from K, necessarily you are causing somebody to face some cost. Some cost is being imposed on somebody or the other if you move into the red areas. But the red areas don't cover all the areas within the triangle of AOD, right? It covers only these two patches that runs along the green triangle. And that's because these two red patches represent those areas in which, yes, you are imposing a cost on somebody else. Yes, you are causing somebody to be worse off than they would be at K. But the amount of betterment for the other participant is so much that theoretically they can compensate the person who has been made worse off. So broadly, this is what a cost benefit analysis is about. You impose a cost on somebody, but if the benefit is greater than the cost, then you can move forward with that policy idea. So these are the two broad concepts of efficiency that get applied in a lot of policy contexts. These are concepts of allocative efficiency from a more economic angle. but they're concepts that have been designed more to help with policy questions. So an example to help understand this. All right, I'm bringing up this example from constitutional law, and it's probably an example that will be familiar because it is also a question which comes up in education. Reservations are provided to members of scheduled caste communities, and broadly constitutional law provides these reservations. And yes, the question of redistribution as a concept of reservation doesn't necessarily imply efficiency. If you redistribute, your aim is often something other than efficiency. But let's presume for now that redistribution also produces allocator efficiency, just for the purposes of this example. All right. So your aim in providing reservations to scheduled caste members is can be pursued in various alternative ways, as soon as you consider the possibility that you can subclassify between members of scheduled castes. Recently, courts have had to deal with this question because previously the whole category of scheduled castes was considered homogeneous, which means every member of one caste within the scheduled castes is treated exactly the same as any other member of a caste within the scheduled caste category. So if there are scheduled castes that are better off and some scheduled castes that are worse off, then there is no differentiation between them that the reservation scheme currently engages in. So now the courts have had to deal with the problem of whether we should subclassify, whether we should allow subclassifying between scheduled castes. And when that question has come up, they also have had to face the question that if we subclassify between scheduled castes, legally speaking, this was a legal question, can we subclassify between them and provide more benefit to some scheduled castes who are worse off without reducing the benefit of the other scheduled castes? Or is the quota of scheduled castes fixed, and any increase of the space that you provide to the worse of scheduled caste necessarily has to take away from the better of scheduled castes? This question, I would suggest, is largely paralleled by this idea of Pareto and Kaldor-Hicks efficiency. If you argue that we can increase the scheduled caste, the reservation for certain scheduled castes without reducing the reservation for other scheduled castes, then you are aiming for a Pareto efficient analysis. Of course, you will then be taking some seats away from other non-scheduled caste members, members of the general category maybe. So that's again not Pareto, but the idea is, let's take it within the field of scheduled castes, and that's Pareto. Kaldor-Hicks is when you do increase the seats of certain scheduled castes, but that necessarily reduces that of somebody else. So what you need to understand is that this concept of efficiency is where all the policy arguments for law largely derives from, and even certain instances of interpretation of the law also comes from this angle of efficiency. I'll give you an example of this as well. When courts had to decide what is the way in which they determine whether or not somebody has a duty of care to ensure that there is no accident, how do they decide whether or not that duty has been kept by a person or whether that person has been negligent? There are legal rules on negligence. There are rules regarding liability that is imposed on individuals when an accident happens, right? You have to figure out who is liable when an accident happens. And this kind of a question, courts had for a long time had problems with dealing with them. They would say, what is a reasonable duty of care? And they would use a term like reasonable as if it explains what that means. It gives some guidance about what exactly is a reasonable duty of care. Instead of going about in this ambiguous fashion, economists suggested that a better way in which to understand what is a reasonable duty of care is to be able to compare the two costs that come up from accidents and from preventing accidents. So if the cost of preventing an accident is so high that it is more than the cost of an accident if it did take place when you did not take that precaution, then that is supposedly a duty of care which is not reasonable. An example of this, let's say you are required as part of the law to always drive at 10 kilometers per hour, or that you are required as per law to check the parts of your engine, all parts of your engine every week. You're required to do so. The cost of this precaution is so high that it is suggested it is probably more than the cost of the accidents themselves. And this cost benefit analysis suggests that there is a point of equilibrium where the cost of accidents, the cost of precaution to prevent accidents is equal to or approaches the cost of the accident itself. And that is the optimal level of care that you should be taking in preventing accidents. And that's what courts should be trying to look at. If somebody was driving at 10 kilometers per hour and an accident took place, it's probably likely that they'll say that you were not speeding, right? Instead, if you want to determine what is speeding, but there is no signboard up anywhere which says the 50 kilometers is the speed limit here, and the court is having to decide was the person speeding at a particular point of time, then the questions start to change. You start to look at other questions about what is the reasonable duty of care given the amount of traffic on a road, given the amount of pedestrians on the road. Was the road a highway? Was it a small lane? Was it nighttime? Was it daytime? All of these questions start coming up and determining what is the reasonable duty of care. But the question can still be answered by seeing whether the cost of preventing an accident was higher than the cost of a potential accident. That's one example in which economics tries to provide a policy argument or a policy suggestion about how the law should be like. The way in which they try and explain how law should come into place for the first time, whether there should be a law in the first place, or whether things should be left to market forces, is this trigger, which is called transaction costs, right? Now, transaction costs is a concept that was developed to explain why markets or transactions can't, in the first place, solve all problems. The idea in mind was this, that if the costs of engaging in transactions was zero, if there were zero costs to engage in transactions, then every valuable thing would automatically end up with the person who valued that thing more. Why? Because since the transaction is possible, somebody will be willing to sell it off to somebody else who values that thing more. And if that person really values that thing more, they would be willing to pay for it. And the transaction would take place. And eventually there would be allocative efficiency because things would go to the people who value them most, right? What really happens when transactions are not possible because transactions are made costly? I mean, to start with, of course, transaction costs aren't a blanket trigger for when the law should step in. The law has to exist for markets to, exist in the first place. You need property law, you need contract law for markets to function without coercion, without fraud, with contracts being enforced. All of these things need to happen. So law needs to exist in the first place. But how theorists have tried to explain this concept of the minimal law that you need to have markets running versus other laws that interfere in markets is that they try and look at these two concepts of property and liability, right? There is this one simple test that they try to apply to explain when is a rule or when is a kind of a legal system a property system, and when is the legal system or a legal entity a liability system. What is property? A property system is basically where the legal rules determine that you yourself or the owner of the property themselves can make two choices on their own. They can decide when to alienate or give away or sell their property to somebody else. They can decide that, and they can also at the same time decide at what price they will be willing to alienate, give up, or sell their property. That is the hallmark of a property rule, that the owner is able to decide the price of transfer. What happens in a liability system is that transfers are taking place. There is some transfer or the other taking place where a liability rule is in place. But the price of the transfer is not determined by the owner, the so-called right holder or the owner. The liability rule decides how much the price is going to be. So, for example, if there is a case in which somebody has hit you and and you've been injured because of it, then uh, you could say that if you had a right to this thing, it was in a sense your property as well. Your body was your property as well, and you could say that it should have been subject to a property rule. But a liability rule determines in this situation how much that transfer is worth. What has been transferred here may not be very clear. Basically, somebody has been given the right to affect your body in a way. So they have obtained something in terms of a benefit or a good, which was not previously available to them. We are calling it a transfer because we're using this kind of economic language to explain these things. But this is how economics explains what a law does. It places a price on something which is not determined by you, but is determined by somebody else. And the trigger that is supposed to decide when there is a property rule and when there is a liability rule is basically transaction costs. If it is impossible to determine what is the appropriate cost at which you should be transferring that benefit, some benefit or the other, you will have a governance system impose that price because the transaction costs are too high. You could say that in most circumstances where coercion has taken place, where somebody has hit you for some reason or the other, that's probably a bad example, but those are instances where people are undecided about what was the cost of that thing. I could easily claim that it was a very costly accident for me and it was very harmful to me, and I suffered considerably in terms of physical and mental well-being. On the other hand, the other person might say that no, it wasn't even my fault. I was enraged. You said something to me which made me angry. So that's why law has to step in and create these rules to determine where transaction is not possible because people are unable to cooperate and unable to give valuations about what their cost of a thing was. The law has to step in and determine how that value should be decided because the transaction costs are high. What this does, though, for law and economics is that it creates a lot of bias in favor of transaction in markets. And it's possible to view things from you can make the argument from the point of view of cooperation as well. Instead of transaction being the default, you can think of cooperation being the default, or conflict being the default as well. The way I try to sort of explain this is that while an ordinary explanation of what happens when you buy something from a grocery store is that it is a consensual transaction and a bargain is taking place and you're consensually transacting. Say you're buying a packet of bread from a grocery store. You can say it's a consensual transaction. But another way to look at it is that markets are functioning as a conflict resolution system. They're actually an alternative dispute resolution system. What is the dispute? There could easily be, conceptually speaking, there could easily be a dispute between me and the grocer, suggesting that I want to take that bread for 1 rupees or for no cost at all. I just want to pick up that bread and go away. That is the full extent of my preference, so to speak, as a consumer. Whereas for the grocer, it could well be that he wants to give this bread to somebody, but he wants to get in return an exorbitantly high price, say 1 crore. It could easily be the logical end of a selfish, self-interested person, that I want to get a lot of money for this. And in this sense, markets don't promote transactions so much as they resolve disputes between people. Because you might feel that you have a certain kind of extent of your preference, but what really makes your preference, what really shapes your preference and makes it realistic, what makes your evaluation of the cost of the bread realistic, and so to speak, makes a transaction for the cost of the bread consensual, what makes it so is the information that is passed on when a price system is in place. When a price system is in place and a price system is subjected to the market forces of demand and supply, it arrives at a resolution of your dispute regarding the value of that price of bread that may otherwise have been unresolved, right? So I want you to understand that even when you talk about core economic questions, you're not always talking about markets and transactions and consensual transactions in a way that is devoid of disputes, conflict, and the question of how cooperation can be promoted by collective choices or by social choices. Another critique, I put it here, but it's probably best if we think about this critique from point of view of the of what we'll be discussing tomorrow about an evolving standard in law and economics. But I'll give you this example now itself, so as to give you a little bit of an understanding of what are the problems with concepts like Pareto efficiency. I explained this concept of Pareto efficiency previously, which suggested that if you make some people better off without making anybody worse off, then that's a minimum criteria of economic value, that you have created something without harming anybody else. Now let's think of this in terms of a legal question like the Citizenship Amendment Act, right? The Citizenship Amendment Act was an instance in which benefits were provided to members of certain refugee immigrants from certain um, religious groups. They were essentially, they were provided accelerated naturalization, accelerated pathways to citizenship despite being from other countries, right? So this benefit was provided, and proponents of the CAA suggest that there was no cost imposed on anybody else. We are benefiting some people, we are not harming anybody. So surely this should be Pareto efficient, right? What really is the problem with the CAA from an economic angle? And this sort of a question also comes up in any question of discrimination law or discrimination per se. Economics has a lot to say about discrimination law. Many economists find that discrimination law shouldn't exist, because even if consumers or producers have discriminatory preferences, those are still preferences, and they can exercise those preferences if it turns out to be that market forces do not allow for those preferences to exist, or they place prices or costs on those preferences, then those preferences might get filtered out and they might not be able to manifest. But if it is manifesting, it's creating welfare supposedly. So these are some challenges that we might have to discuss the next time about what really economics has to say about these kinds of distributive questions. Lastly, I want you to look at this point about market failures. This is probably the fulcrum on which much of law and economics operates. These concepts of what exactly is a market failure are the reasons why economists are very much in favor of there being legal institutions, why we need government to exist. And what do market failures mean? They mean basically that markets, if allowed to operate freely, would nonetheless give rise to suboptimal levels of utility. They don't result in aggregate utility being as high as they could be. So the kinds of market failures are also important to understand, because depending on the way in which markets have failed to produce aggregate welfare, higher aggregate welfare, depending on the way in which they have failed, the policy prescription or the suggestion you have to make about how should we resolve that market failure through some government intervention is going to be different. It all depends on what is the way in which the markets have failed. One of the prime and most acceptable forms of market failures are monopolies. They exist because all kinds of markets can produce monopolies almost naturally. They might exist because of anti-competitive practices. They might exist because of natural monopolies. All kinds of reasons might exist why somebody might be able to monopolize a market, and then, despite the market being free, give rise to lower levels of welfare. And what this means is that governments often have to step in to produce better consumer welfare. And they might have to do this by creating competition law, what is called competition law. All kinds of anti-competitive practices like predatory pricing, or tying up goods in a way that you have to sell one with the other, otherwise you can't get the good at all. All of these kinds of practices, various anti-competitive practices, are what competition law aims to deal with. One example of this, monopolies are one problem that those who work in the field of digital policy on the internet, policy on the platforms, policy on internet intermediaries, are they very concerned with this problem of what happens when digital monopolies are formed. There was, for example, a long concern that things like companies like Microsoft would have a monopoly on certain kinds of digital products. There have been concerns recently that Facebook has monopolies in certain kinds of products. And that's so because of there's a particular economic reason why that's so. Network externalities basically promote these kinds of monopolies. How does that work? Basically, a network is more useful for each member of the network depending on how big the network is. If a network was very small, the value of that network for each individual member would be less than if the network was bigger. So what this means is that bigger networks, because they automatically give more benefits to the members of those networks, are naturally forming in the digital realm. They naturally form because they are producing better goods, better services for their members, and they're difficult to displace because incoming incoming platforms, competitors of this existing monopoly, are unable to produce a network of the same size. So because of this, the legal solution that has been developed is data portability, which suggests that if you personally have some data that is being stored by a particular digital company, then the law legally should be requiring that company to port that data that they have on you to any other company, any other platform, any other digital platform that might be competing with this one. And that can be done at your choice. You as an individual can say that, hey, I want my data to be moving from Facebook to some other platform because I don't like what I'm finding in Facebook as a consumer. That choice of a consumer to be able to shift from one to the other is promoted in this fashion. So that's one example. Another example would be externalities. This concept is actually a little contentious because it's not very clear who exactly should be considered to be the person who is causing an externality. What is an externality basically? Economists try and talk about this concept of externality by suggesting that when two people transact on a good, it's not always the case that the only people benefited or harmed by that transaction are the parties to that transaction. A third party to that transaction can also be benefited or harmed by that transaction. When you buy something which has been manufactured in a factory, supposedly maybe an economic angle of looking at it would be to see whether or not consumer satisfaction exists and there has been profit created by the company that is selling the good, right? If I buy a pencil from a pencil manufacturer, an economist might suggest that all we need to look at is whether or not I am happy with the pencil and whether there's profit created by the pencil manufacturer. But at the same time, it's very clear that the manufacture of that pencil has also created some kind of pollution, maybe. Some trees might have had to be cut. When the lead was being mined, there had to be mining, maybe. There might have been pollution when you're creating the lead pencil's nib. So all of these costs that are created as a result of the manufacture are not necessarily being borne by either the manufacturer or the purchaser of the pencil. It is instead being borne by everybody at large. That's an example of an externality. In various situations, it's not clear what the externality is. Some scholars of law and economics like to think of this as a reciprocal relationship. If you require people not to, so I mean, we intuitively feel like this example of a pollution is an externality because we believe that there is an existing right of individuals to clean air, to clean water, to clean air, to I guess natural resources being existing in the form of forests. This intuition, though, is sometimes challenged by economists as well. They say that if you want to impose a cost on companies from producing certain kinds of goods, then it's actually a reciprocal relationship. The externality isn't necessarily on individuals. There is also an externality on companies who are producing things, which basically means that you have to figure out who is having to bear the higher cost when there is a relationship like this. Another market failure is this idea called public goods. Public goods basically are those kinds of goods which need to be produced by some common entity like a government because private entities in a market do not have the incentive to produce it, or they have every incentive to underproduce it. The example I give for this is armed forces. Let's say you were living in a country where the question of national security or the question of physical security from external aggression from another country was left to private markets. Then what could easily happen is that these private markets, which are producing security, physical security, which are producing the basically you can say private armed forces, they would be paid for more by the individuals who are living at the borders, who are closest to other countries. and who have the most likelihood of being attacked by some other foreign aggression. Because they will be paying for it, these armed forces will be protecting the borders, but that same protection would at the same time be giving protection to people further away from the borders who are not paying for these armed forces. As a result of these kinds of problems, where individuals have benefits from armed forces regardless of whether they live at borders or not, the simple idea is that a private armed a private market situation for dealing with a question like armed forces would be clearly inefficient, because if only people living at borders are paying for it, then it is going to be underproduced. It is not going to be produced at the levels it would be if the nation as a whole was paying for it. Individuals who are further away may not want to pay for it because they already know that somebody is paying for it at the borders, who are living closer to the borders. Basically, somebody in Punjab paying for a private armed forces for aggression from Pakistan would also be benefiting somebody in Delhi or in Bombay, who is benefiting from the fact that the Pakistani army is not coming in. So instead of leaving armed forces production to a private market, it is clearly more efficient to leave it to a national production. It will be produced more efficiently. The other angle, the other side of public goods is that certain public goods, the one that I talked about are public goods that have not been produced or that are not being produced because private markets don't have the incentive. The other side is that there are certain public goods that already exist. They are commons, nobody really owns them. And because nobody really owns them, nobody really has the incentive to maintain them. Think about something like a public pond. A public pond that nobody really owns, everybody has a small incentive to maybe throw a little bit of litter or to leave their trash around the pond or to have their sewage go into the pond and spew sewage into the pond, because they don't have to care about it. It's not their property. They don't monetarily lose out on anything when the pond is dirtied. But if that is so, if nobody really cares about it, the pond will be dirtied by everybody. Everybody will have the incentive to do so. And in the end, society will be worse off because of the polluted pond. And this kind of pollution is a problem which is called the tragedy of the commons, which also suggests that there can be reasons for government intervention to prevent these kinds of tragedies. There are some arguments that what this means is that there needs to be privatization of things that can get eroded in this fashion because everybody wants to use it up. And there are other which suggest that there needs to be government ownership or common ownership over these kinds of things. That's a debate that we don't need to get into right now. A final market failure is called information asymmetry. I'll give you one simple example of how the person who first explained this, George Akerlof, the example that he used was information asymmetry in the used car markets, in the market for used cars. So used cars are being sold in the market right now, let's say, and these used cars are being sold without telling people necessarily that they are used cars. There is no requirement for you to say that it is a used car and somebody has previously used it. If this is the world in which we live in, what is really happening? The cars that are being sold to people, there is a lottery for people. They don't know whether this is a newly manufactured car or it is a used car. If they don't know, they are bearing a risk. And if they're bearing a risk, they are likely to want to pay less. If they had assurance that the car is good, they might be willing to pay more, right? If they don't know and they are bearing this risk, this cost on them, they value the car less. They don't know whether the car is a good car or a bad car. If the value of a good car is 100 and the value of a bad car is 50, through some expected utility calculation of the probability of that car being a used car, you multiply the probability by the likelihood of the cost, and you get something like maybe 75. You'll instead be paying 75 instead of 100. But the result of this is that people generally are paying less money even for new cars. And society as a whole is made worse off because there is lowered demand. There's less willingness to pay for cars. So individuals who are producing cars are receiving less revenue and they are going to underproduce cars. What has really happened here? The kind of market failure that has happened here is information asymmetry. Certain qualitative factors about the product which is being produced have not been communicated to individuals who are buying that car. And so society is worse off because things are being underproduced, because people are paying for it less, because they are having to bear certain risks. The broad solution from this kind of a market failure is basically consumer protection, disclosure requirements, where by law you are required to disclose that this car has been used. This car has been used by so many years. If this car has been through an accident, you have to disclose that as well. And all of these things are taken into account by consumers, who can now pay full 100 for a new car, and they can pay only 50 for a used car, according to the valuation that they see, depending on the usage of the car already. So this is again something that won't happen if you leave things just to markets. You need some legal intervention to ensure that this information asymmetry is solved. Many scholars also try to argue that just because there is a market failure, that some certain kind of um, suboptimal situation has arisen because of a free market, that does not mean automatically that a government should be given license to intervene and create rules. This is broadly argued from the line of government failure. Governments, when they intervene, may actually make the situation worse. So there's actually two requirements before, according to economists, there's two normative requirements before you can consider government intervention to be necessary. One, market should be failing, they should be creating suboptimal levels of human welfare. And secondly, if a government intervenes, it should produce higher levels of utility than even that suboptimal market was producing. If both these conditions are met only, economists suggest that government should intervene, that there should be laws. So that's broadly where I'm going to leave this set of discussions about what the existing paradigm in law and economics is like. From this existing paradigm, maybe you've already gotten some hints. There are various things that might have sounded distasteful, disagreeable. You might have been dissatisfied with the way this is dealing with questions of law, dealing with questions of rights. And I would invite you to think about this more, that if you apply economics to these kinds of situations, are these necessarily the outcomes and the conclusions that you have to arrive at? Are these necessarily the reasons for which governance and law exists? If you apply a standard only of efficiency, many of these things automatically come forward. If you have other values in mind, if you have a more pluralistic mindset about where normative goods lie, then you might come at other answers as to what law means and what economics even has to say about law. Right? That's something we'll try and discuss tomorrow. That's something that even I'm trying to learn about. So I'm inviting you to sort of join me in my journey in trying to explore this idea. Why am I concerned with these ideas? Because lately it's difficult to explain various questions of rights and laws to individuals who might believe that these kinds of rights and these certain kinds of laws that supposedly exist for liberal democracies are not meant for India. That they don't fit with Indian culture, let's say. So it's one aim to try and look at this in terms of economics, because economics is accepted by individuals across cultures as supposedly a culturally neutral value. So if you can explain why, in realistic terms, certain kinds of laws, rules, and rights, certain kinds of liberal principles even, produce greater human welfare, that is culturally neutral and should be able to persuade people, regardless of their cultural affiliations, that this is something that is worth putting our backs behind as well. So that's something as economic students you should be concerned about. What happens when you have a narrow, purely instrumentally rational, efficiency based mindset, but also how economics can be used to counter other kinds of problems by using culturally neutral languages. To end today's discussion, I just wanted to put forward these two questions, and I wanted to hear if you had any views about them. I can drop out of the PPT if we like right now, but if you want to read the questions, I'll just leave them up here for a moment. These are two questions. A few moments ago, I was discussing what are the different kinds of market failures that exist. I listed out four kinds of market failures: monopolies, externalities, public goods, and information asymmetry. Now I want you to zoom in on one particular legal field that is emerging in India, which is called data protection. It's a field that is meant to promote informational privacy. Why do I say informational privacy? Because there's also another kind of privacy called decisional privacy, where individuals are supposed to have their private rights to decide on certain core questions like marriage, like sexual orientation, like gender identity. That's decisional privacy. That's to be differentiated from informational privacy, but they still use the same words, privacy. Anyway, I'm talking about informational privacy. What does informational privacy concern itself with? It concerns itself with personal data and the protection of personal data. What is personal data? Personal data is data that basically identifies data uh, that allows you to be identifiable in some way or the other. So that data might exist because of a combination of various pieces of data somebody holds, or it might be on its own very identifiable. Something like a name, something like a registration number, something like a number plate of a car. These things can all be identifiable to individuals in ways that doesn't exist for, say, just data on height. Just say height, just say the height of 20,000 people in Delhi, and you don't necessarily identify anybody in them. So that's not personal data per se. But if you have a smaller data set about how many people have this kind of a height and also do XYZ, slowly, with a combination and aggregation of data, it can become personal. So I want you to try and think about what happens when you leave transactions of personal data, transfers of personal data, and the possession of personal data purely to the market. Would the market give rise to optimal levels of welfare, or would there be a market failure? If there is a market failure, what market failure would you think that is? So that's one question. The second question, you'll remember I talked about the differentiation between property and liability, and how you switch between them depending on whether transaction costs are high, right? If transaction costs are high, it's difficult for a legal system to suggest that all problems related to a particular subject can be dealt with through a property system. You might have to impose a liability system to decide that, oh, this has transferred from this person to that person. We can't leave it now to the market. We need to decide what is the price at which it is going to be transferred. We need to impose liability, a fixed imprisonment sentence. It could be a fine. It could be some kind of a penalty. It could be a requirement of compensation of costs of the harm that is caused. All of these are liability rules, and they're different from property rules, where I, as a property owner, decide how much is the cost of a transfer. So the question of personal data, is it supposed to be, or would you think it should be treated as your property? Should you consider your personal data as your property to be transacted at the cost that you want to transact it at and to the person that you want to transact it to? So I'm going to leave the floor open. I'm going to ask if it's possible you want to raise your hand and say something. You can do it that way. You want to maybe say it in the chat box, you can do it that way as well. But those are the two questions that I wanted to pose at the end of this. Somebody's raising their hand, and Manya, you're not audible. I think you're muted.
She's had her hand raised for a while now, so I think I'll give her the permission to talk.
Sorry.
Dr. S. Selvi.
Oh, since a while. Oh, was there a question then? Oh, we can also have questions. The exercise can be immediately after. Dr. Selvi, if you have a question to ask, please ask that in relation with the talk so far. Or if you wanted to discuss the questions I've raised, you can do that as well. But generally, if anybody wants to talk about the exercise at the end, you can also raise your hand. All right, Dr. Selvi. I think he or she is not at the computer, or they're not listening to me anymore. No, Dr. Selvi, you had something to say. You can say it now. Okay, you can't.
Maybe she just raised it by mistake or has forgotten about that.
Possible. All right. See, I don't have much else to say for today's session. So the floor is open for either of the two things. Any questions that you might have about what you've heard, or any views that you might want to pose about the questions that I raised at the end, the two questions.
So I have a question. I mean, has there been, in your view, an Indian law at a macroeconomic level that has achieved Pareto efficiency, or is that like a utopian thought to even have?
I mean, any law which doesn't, I mean, which has expanded the pie without reducing, say, uh, core laws that promote what a market does, like a contract law, is very likely to be Pareto efficient or Pareto improvement. Why? Clearly, because the alternative of not having the law is that there is considerable harm from contracts not being enforced, from
Yes.
people breaching their contracts without any liability. And the general reciprocity, the trust that is created when you know that there is an authority that will enforce your contract, automatically makes everybody better off in society. And that's a clear win-win for everybody. Nobody's actually at a loss from a law like a contract law. Would there be anybody who would say that, no, I would have preferred a society in which contracts were not enforced? I really think that I'm good at that, breaching my promises and breaking my contracts, vice versa, whatever. If somebody like that existed, then maybe this is a Calder Hicks situation. There's a cost benefit involved. But actually, it's a very universal benefit that a contract law creates.
Right.
Anybody else? Anything? Anybody was sort of was anybody somewhat provoked by the discussion about discrimination particularly? Would you think, for example, that discrimination can ever be explained in terms of economic efficiency? These are some questions that you can think about before tomorrow. If there is nothing, then evening, end it for tonight. Have a good Saturday evening. Enjoy yourselves. Come back tomorrow.